Well, good morning, everyone. Welcome to our second webinar Beasley Allen's putting on. We're excited to have you this morning. I have really enjoyed doing these. One of the aspects about doing these webinars that I have enjoyed the most, I didn't realize that it was going to be this way, but was the follow-up. I've heard from so many people who watched the first one and sent me emails and asked me questions, and even went to lunch with some folks who watched the first webinar, and I enjoyed meeting new people. And so that was a neat experience for me, and it was worth doing it just for that. And so I'm excited about that. I'm excited about this one today. I've got guests this morning. To my right is Kendall Dunson, one of my law partners in our Montgomery office, but Kendall grew up in LaGrange, Georgia. Your dad was the clerk of Fulton County, right?
He was for about 12 years.
All right. Yes. So you've got some deep Georgia ties there. And then to my left is Cole Portis. He's the section head of our personal injury section where I work. And you're born in Georgia, right?
I was born in Albany, Georgia.
Albany. Yeah. Well, good deal. Well, today we're here talking about a trial that took place during the COVID pandemic. It's one of the first trials that I know that went all the way through, and these guys are going to talk to us a little bit about it. But before we kind of get into the COVID aspects of the trial and those things, tell us a little bit about the case itself.
Well, a little bit. We represented a lady from Louisiana and her son, and they were traveling on Interstate 10, and as they were traveling down Interstate 10, they were from Louisiana, traveling across, trying to go to South Carolina to a family event. Also with them was the husband and father of the child. And unfortunately, there on I-10, there was a wreck in front of them. And as y'all know, when wrecks happen, the traffic kind of starts to back up. Unfortunately, they were not aware that a man named Willie McMillan had been at a dog track all day. And the primary reason he'd been at that dog track was because it was horse racing day, and the Belmont Stakes were in place. And so they had simulcast, and they had betting that was going on related to those horses. And when Willie McMillan went to the dog track, he stayed there most of the day, and as you can imagine, consumed quite a bit of alcohol. And so around 8:20 that night, he left the dog track and proceeded to start to head home. And on his way, around 8:30, he didn't realize that traffic was backed up. And because he was intoxicated, he ran into the rear of our client and killed the husband and the father in this particular wreck. And so that was what this particular trial was about. It was a Dram Shop case against the Greyhound track.
One of the things that I saw in getting ready for kind of the webinar today was a timeline, and it looked like this case went through quite a complicated procedural history before it got to trial. Tell us a little bit about what you went through to get to trial from a procedural aspect.
Well, procedurally, as you can see on the timeline, we actually showed up to trial in 2018, and there was we were ready to start the case, ready to pick a jury, and the judge came out and told us he had changed his mind. He had denied summary judgment, and then he decided to grant summary judgment on the issue of whether or not the plaintiff had competent evidence of intoxication. Before this case, the rule of law in Alabama was you needed direct evidence, someone who saw the person intoxicated and being served alcohol by the proprietor. As a result of the appeal that we filed, it is now clear that you do not need direct evidence. Circumstantial evidence is sufficient to prove your claim. So you look at the totality of the circumstances. And in this case, as we'll find out shortly, it'll become extremely important as to why that change of law is so paramount. In 2020, we were getting ready to try the case again. And the Friday before the trial was to start on Monday, we got an order from the judge saying the case is continued because of COVID. This was in March of 2020. And then we had to wait again. And so finally, in October of 2020, we were able to select a jury and start the trial of this man.
I know that it's always hard to get a case to trial and you're getting ready. You've got a lot of issues. It sounds like there were some legal issues, loopholes you had to jump through. At some point, there was a decision made to use a jury consultant. Talk to us a little bit about, when that was made relative to the trial and why and what you learned.
Well, we decided on the jury consultant before the second trial setting. We didn't have a jury consultant for the first trial setting. And really, one of the issues that we were concerned, we were concerned about two issues is, one, how is the jury going to transfer or consider the liability of the server of alcohol as opposed to putting all of the responsibility on the drunk driver. So we needed to really work around that. And then two, we had a corporate citizen in that community that was very active and was, did a lot of charitable events. And we really wanted to figure out how to deal with that as well. And so we brought in a trial consultant, which encompassed more really than what our original two goals were. Certainly addressed those two issues, but we went beyond that. And I thought that at the end of the day, that the trial consultant was extremely valuable to us.
Was there something that, and maybe there wasn't, but was there something that you did differently? You probably did because of using him that maybe you wouldn't have done otherwise.
I just think that it helped us clarify what our themes were. I think that it helped us clarify really what the defenses were of the best defenses. It was so interesting to me, Chris, when we were sitting there and I was listening to the opening argument of defense counsel. We had already written the defense counsel's opening statement, and he got up and he did a fine job in his opening statement. But I'm going to tell you, the one we wrote was much better. The one we wrote was much better because we had really struggled with those issues and made as good an argument for him as we could make, so that in turn we could address what those issues were appropriately.
That's great. I'm going to use that same jury consultant on a case I've got coming up soon. So I'm excited to go through that process.
It's a neat process. Kendall and Graham was also involved, Graham Esdale, but Kendall and I met with this trial consultant over a 2-day period of time where we just went through and struggled together with the testimony, really figured out what our best arguments were, what our weaknesses were, just had kind of a come to Jesus meeting about what our weaknesses were. And sometimes I think that especially me, especially once I'm going to trial, I am an optimist. I don't even care what the defense lawyer says. It's clear I've got to go to trial, so I'm not worried about them as much. I thought this was helpful for me though, on the front end, months prior to trial, to figure this out and to be able to really appropriately address what those arguments were.
That's great. Yeah, I've noticed practicing law as plaintiff's lawyer that defendants don't generally want to go to trial. They want to delay. But I can only imagine that those arguments were kind of on steroids when you've got COVID as an excuse to delay. And so talk to me a little bit about some of the obstacles you faced just getting in the courtroom, other than all the procedural things you talked about. I'm sure that COVID was a big one.
It was. And as a matter of fact, with the trial consultant, one of the issues we discussed was COVID and how do we address COVID? How do we interact with the courtroom staff? How do we interact with potential jurors? And then once we ultimately chose a jury, how do we conduct ourselves in the courtroom? So COVID was very much on our minds before this trial.
Let me stop you right there because I want to get back to your question. But on the COVID issues, and I do think this is important. What we determined is, we were going to be surrounded by a lot of plexiglass. Everybody was going to be in masks. But what we decided and what we determined and what we discussed was that we weren't going to mention the word COVID at all. In other words, I wanted you to get up and in board hour like I did and go, I appreciate y'all coming here. You know, this is a really tough time for our nation. And I know everybody's concerned about COVID, because really what was intentional and what we had to do, Chris, is that we had to get the jury focused on our case. And there were already the distractions around us, and we didn't want to draw additional attention to that. So I just wanted to make that point. But there were some other issues that we had as it related to COVID.
Exactly. It was Saturday night. We get an email from our primary toxicology expert, and he's contracted COVID.
Wow.
And he can't show up to trial because he has to be quarantined. So we had to have a motion practice with the court on Sunday. And about 1:00 p.m. on Sunday, we had a telephone hearing about the issue. Of course, the defendant wanted to continue the trial. We proposed that the judge allowed that witness to testify via Zoom. And that solved the problem of the witness having to be in the courtroom and forego quarantine. Of course, the defendant said, well, look, it prevents me an opportunity to properly cross-examine this witness because I need to give my materials to the plaintiff before I cross-examine the guy so we can put that information on Zoom. We quickly got in touch with our IT staff who came up with a solution, which was, no, you don't have to. You have your materials on a thumb drive, and when you cross-examine the witness, you stick your thumb drive in, you call up your documents right there on the spot, and plaintiff and witness never sees it before you cross-examine that witness. So it shows you how important it is to be prepared to deal with that, because that could ultimately occur, and also to have competent support staff who can come up with a solution to that problem.
Wow, that's really creative solution to a legitimate concern that the defense had.
It was a very legitimate concern, and the court was hung up on that. As a matter of fact, that was the only issue the court really focused on, was how do I not prejudice the defendant from doing an effective cross-examination. And for the record, everything went well via Zoom, and there was nothing that was shown in his cross-examination that we had not already seen in that witness's deposition.
Yeah, and I do think that the court in this instance was concerned about that very issue, but at the same time, the court was being pulled by this strong desire of wanting to try a civil case in Alabama during COVID to show that it could be done. And so all of the precautions were taken. Everybody was apart. They had enough space and room. We redid the courtroom and all those things. But this court was committed as much as it could with that one issue that came up to making sure that this case went forward with COVID. Because even before then, the defense counsel was like, oh, no, we can't do it. Our people can't travel. We're not going to be able to do it. Well, the people were able to travel and they were able to come to court. And this court just kept pushing because the reality was the court's docket was getting backed up. The court needed to be able to show we can do this. Going to set some more cases for trial, and therefore we can get some of those cases that are on my trial docket resolved before trial.
I think that's going to be critical to have courts that are committed to helping us get our cases tried. There's been a lot of talk, I noticed in the last few weeks on the Georgia trial lawyers listserv about voir dire. I mean, it's an issue. We're all wondering, how is it going to change? It's my understanding Fulton County is going to do it by Zoom. I've seen a lot of concern about that, about how do you get people to open up on Zoom. A lot of people are just being quiet. They're not speaking up, but you all were able to do a live voir dire, correct? And tell us a little bit about how that was done safely.
Well, in this instance, this particular courthouse had a large ceremonial courtroom. And so they brought in I'm trying to remember how many jurors. I think we had 50.
Yes.
About 50. And we're able to spread them 6 feet apart, everybody masked, everybody getting temperature checks before they came in. Now, we decided that we were going to wear the the clear plastic shields as opposed to the face coverings, because I wanted them to be able to see my lips, to see them move, and it's because sometimes people can see what you say and as it relates to hearing. But I also wanted to jump in really quickly, and I will say this: I wanted, and this court allowed us to do personal voir dire, and so I wanted to jump in as quickly as I could and ask personal questions that were case related to individual jurors, just to get some of them used to talking, because you could tell some of them were extroverts already and some of them were introverts. And so I asked the extroverts those questions initially because I knew that would prompt some conversation and get them comfortable and get them to open up.
I'm sure that people were, in the room were concerned about their health. Did it ever come up at all?
I don't remember it coming up, do you?
No, only once, when I think a particularly smart juror came up after voir dire and said, "I want to bring the issue to the court. I hadn't been feeling well," and he gave some COVID symptoms and was able to be excused from the binary because of that. That was the only issue, and luckily for us, we didn't like that juror anyway. So we were very happy that he came up and gave his excuses and was excused from service.
Let's look a little bit about how the room logistically was set up. Talk to us about the way the court protected all the participants of the trial by the way the room was arranged.
As you can see from the photograph, the court took it very seriously of protecting the court, its staff, the jurors, and the parties. You see the partitions. The judge was separated by his own partition. The witness was separated by his partition. As you can see, out into the grand, well, where the public normally sits is where the jury sat, and they were spaced 6 feet apart to make sure they were safe from each other. You see those, there were 70-inch televisions. Because the jury was so far from the witness, we had to put a microphone and a closed circuit camera in the witness stand so the jurors could get a close-up view of the witness. And I believe, we had to provide those televisions. So be prepared to bring technology into the courtroom. And the court put it upon us to say, okay, you want to try this case, then you have to help us out, bring the technology that we need so that we can safely conduct this trial. So the one thing that was concerning was when you're having a witness on the stand, your back was turned to the jury behind you. Normally, as you take a witness, you can see the jury on your right or on your left. You can gauge their facial expressions. So I found it particularly concerning to myself that I'm taking a witness and I can't see the jury's reactions behind me. Other than that one issue, I think everything went very smooth.
No, and I think, Chris, and I don't know if this is a good time to talk about that, but I think that was a crucial part of this particular case, because we weren't able to gauge or understand exactly how the juror was accepting the testimony. Now, we felt good. The evidence was coming out exactly like we wanted it to come out. The arguments were coming out exactly like we wanted it to come out. But we didn't know if the jury was getting it or not. We just weren't able to read them at all. And that was by far the biggest problem that we had in our case.
You've talked about this a little bit already, and our firm always uses tech support at trial. We have, really advanced level document presentation and video presentation. We can change it on the fly. We've got really excellent staff people who come to trial with us. But I can only imagine that the tech support issues were unique because of the courtroom setup, because of the Zoom issue. Talk to us a little about some of the issues that you faced from a kind of a technology standpoint.
Technology was extremely important for this trial. Our team went down the weekend before to set the courtroom up and to make sure that when you're supposed to be seeing a witness and hear a witness, you could see it on those two large 70-inch televisions. But we also had a separate screen for documents. So this was basically a paperless trial. We didn't have any opportunity to say, hand the witness this document, because we put everything up on the screen to prevent that. So the witness had a screen on the witness stand. The judge had a screen from the bench. Each party had a screen on the table, and then the jurors had the two big 70-inch televisions plus another screen. So to coordinate all of that was extremely important and extremely difficult. But our tech support team did a great job of making sure everything went seamlessly, even when sometimes we encountered issues that were unexpected. They were quickly able to resolve it and let us proceed.
Gotcha. I know that you talked about Zoom. You talked about the witness that you had to call. How did that work? I mean, was there laws in place that allow you to call witnesses by Zoom? Or I know that this is an Alabama order. I think in Georgia has the exact same law in place that we can do that, right?
Correct. And obviously we knew, not just because of COVID, but like you said earlier, in any situation, the defendants have an opportunity to get a continuance, they're going to go for it. So we were prepared with this particular order from the Alabama Supreme Court to let the judge know that being able to use Zoom is something that our Supreme Court has specifically addressed, and it's for this particular situation. So here we have this situation where our witness has contracted COVID and can't be there and needs to be quarantined. But that doesn't mean we need to continue the case again. We have a solution. We have Zoom. We've been using Zoom for months now because of this COVID situation. And our Supreme Court has specifically said you may use Zoom. And I think that was instrumental in the court deciding, you know what, plaintiffs are right. We can use Zoom. We can proceed. And that's what we did.
Gotcha. So, the case settled. It didn't go to verdict. But I think that's probably a story within a story. But talk to us a little bit about what drove this defendant to. They've already tried the case once. This is the second trial, and now they settle the case. They haven't offered anything up to that point. What drove them to make the decision that they were going to make? I understand that they actually even filled out the paperwork for a $12 million verdict, and y'all saw that moments after 5 minutes, I think, before you settled the case. So talk to us a little bit about what do you think motivated them?
I think at the end of the day, look, the trial went extremely well. We had a strong case of liability in this case. And I don't know, I don't understand, and I don't know why the Greyhound folks didn't see it. Because here's what the evidence was. Willie McMillan goes and he stays at the dog track all day. We know that during that period of time that he had alcohol. He admitted, yes, I had some alcohol. I want to say he only said he had two.
He admitted to 2 beers.
Not surprisingly, I had 2 beers is what he said. He did say, look, I won I won a trifecta at the Belmont. And before I left, I had a celebratory drink and before I left as well. And so we know that he drank there. We know that was the only place that he was. And we know that he left at 8:20. I mean, we've got the timeline very, very tight. And the latest, the wreck happened, it may have actually happened a little before it, but the latest it happened was at 8:30. And so we know that. And so we know that how that occurred. But here's what we also know. There were multiple police officers. There were multiple lay witnesses there on site who said Willie McMillan was stumbling. Willie McMillan was slurring his words. Willie McMillan was clearly, visibly intoxicated. Willie McMillan had all of the traits that someone would have at 8:30 after this wreck occurred. And so one of the things that we started to play on was 8:30 Willie was the same as 8:20 Willie. So in other words, what you saw at 8:30 didn't just happen at 8:30. That's what he had when he had a celebratory drink. That was what he looked like when he was drinking there on site. And so for us to prove from the totality of the circumstances that Willie McMillan was visibly intoxicated, for us to prove that this particular place didn't have a plan in place to properly observe people, for them not to have in place a way for them to be able to observe, because they thought they could just get a liquor license and sell liquor as much as their heart's desire. But with a liquor license comes responsibility. And so it was important, we kind of had to walk a tightrope because we didn't want the jury to blame Willie McMillan, because in actuality, what we said, Willie McMillan has already taken responsibility. He's in jail. He suffered the consequences. But we also didn't want to blame the bartender per se, because the reality was they didn't give the bartender enough resources in order to properly do the job. And so instead, we had to walk this tightrope. Can't blame Willie, can't blame the bartender. Instead, we've got to move forward and blame the Greyhound Park for really putting a loaded gun on the road with a drunk driver behind us, a speeding vehicle. And so the result was, we thought the trial was going well. Kendall, what else do you have to add to that?
I will add that evidence of that confirmed our faults were after the trial and after the verdict and after the settlement, we were able to talk to the jurors. And one of the best conversations I've ever had with a jury after a trial, because what they said to us confirmed that we got our points across. They wanted to ask us questions. And the primary question they asked us was, did we do enough? Was our $12 million verdict enough to send a message that needed to be sent to this defendant that when you get a license, it's all your responsibility to make sure that you serve it responsibly? And so the fact that they asked that question to us, did we do enough, said to us that our points got across, that this case is about Mr. McMillan because he drove the car. It's also about the server because they serve the alcohol. But most importantly, it's about the license holder who has the ultimate responsibility to ensure the alcohol is served responsibly.
Yeah, and I'll say this, Chris. I mean, one of the important parts is, as I was going in terms of their corporate representative, as I was going through, so I basically just went through the facts and went through what Willie McMillan at 8:30 was looking like. I went through what their responsibilities were as a server of alcohol. I went through all of those things. And at the end of the day, I said, okay, do you have a responsibility to properly serve? Absolutely. We have a responsibility to properly serve, and we can't serve visibly intoxicated people. And he went on to say, I said, look, if you did that, should this jury hold you responsible? He said, absolutely. If 8:30 Willie was 8:20 Willie, then we're responsible for serving that alcohol.
Wow. I know that we tried a case in Gwinnett County a few years ago, and we had a gotcha moment like that, where the defendant just admitted everything we needed them to admit. Was that was where they admitted your thing?
They admitted the whole thing.
Yes. And that kind of tied the jury consultant to the actual, defendant's admission.
That's right.
Wow.
That's right. And see, we were, to talk a little bit more about the jury, Chris, I mean, and this was part of COVID. And I don't, as we go forward, and I know that we're coming out of COVID and it's going to be a little bit better, but our jury, and Kendall and I have tried a number of cases in this particular circuit, but our jury venire was not as good as we typically get in that particular circuit. And so as a result, we ended up with a more conservative jury than I thought that we would get. In fact, the head jury chairperson was the head of the Realty Association there in that city. So we had a very conservative jury, which was part of our issue. Was we also don't know what they're thinking about the case.
Wow. So talk to me a little bit about, you've gone through the experience that we're all kind of jumping to get at. We all want to try cases. For the first time in my career, I think I've got 4 cases completely ready, just waiting on a trial date. And
You need your child.
I need 4 trial dates, and I'm excited to get there. I actually had a dream the other night. It's kind of funny that I woke up in the middle of the night, and because in my dream, I think it was a nightmare, I couldn't remember how to get into evidence. I was like, and I had to wake myself up, that's not true. That's not true. So this week, I had an opportunity to have a live hearing, which was exciting, and it went great. And I kind of walked out of that room and just reminded myself that was just a bad dream. You still got it. You still got it.
Just keep moving forward.
Keep moving forward. So talk to us a little bit about what are some of the takeaways from the trial?
Well, you have to be prepared for anything to happen. Our witness catching COVID was, you wake up, your clothes are packed, your family knows you have to leave on Sunday, and then here you are again. Okay, now we may get another continuance in this case. So be prepared for anything. Be prepared to understand that, like Cole just mentioned, you're not going to get the typical venire, especially in what we call a good plaintiff's venue because of COVID. The people who are most concerned about COVID are likely our better jurors. And the people who don't care about COVID are likely our worst nightmare. So be ready for that and expect that to happen. You have to make a decision. Is it better for me to wait, or is it better for me to push forward? We felt like with our case facts, it was okay to push forward with our trial.
Well, we've got some questions, and so I'm going to do my best to read them. They're a little far away. How long did the trial take?
7 days.
7 days of trial.
7 days.
7 days of trial. So this is an interesting part of the story as it relates to the settlement itself. Do you want to ask another question?
Well, we can go to the next question, but go ahead.
Yeah. So in our case, we weren't able to see the jury. Jury gets charged. Jury goes back. Jury's out for maybe an hour, long enough to pick a 4-person, and then they knock on the door, and they've got 2 questions. And the first question was terrible. I mean, it was just absolutely terrible. And it was basically, they didn't understand the law. They were getting confused on the law. Is it okay to hold a bar responsible or a server of alcohol responsible for the wreck? And we're like, oh my goodness, we didn't do what we were supposed to do. We were freaking out. We're like, you got to be kidding us. And so they finish their deliberations for the day, and then they go home. And I'm like, oh my goodness, these questions are terrible. I got to get this case resolved. We got to get this case resolved. And so they offered the judge was like, y'all need to get the case resolved. And so they offered some more money. And then the jury came back the next morning, and we're there probably, they deliberated for about 3 hours that first day. And then they come back the next morning, they're in for about an hour. And the judge's law clerk comes in to our room. She never goes in another room. She goes, y'all have those flip charts there. Y'all have a flip chart. The jury's asking for a flip chart. And Kendall and I look at each other. They ain't putting facts on that flip chart. They're putting money on that flip chart. And in the meantime, the defendant continues to offer more and more money, putting more and more pressure on our client who's lived with this for now 5 years. And it got to a point where she just felt a lot of pressure, and we were like, look, we can't guarantee you anything, but we think this jury is about to pop it. We think the jury's going to pop them. And she's like, look, these are my goals. I can meet the goals with this settlement, and I'm happy. And we're like, are you sure? I'm sure. So we go in, as we're telling the court, the law clerk comes in and says the jury has a verdict. And the judge goes, y'all have a settlement. I don't care what the verdict is. Y'all have a settlement. And we're like, okay, that's fine. And so we put the settlement on. The settlement is on the record. The jury comes back in. They're told that the case is settled. And you look at their face. We're finally able to look at their faces, and they're devastated. They're devastated. I'm like, oh goodness, this is not good. And so gets the jury deliberation forms and the verdict forms, and he says, Cole, and he calls defense counsel, come into my chambers. And as I'm walking behind the judge, he turns around at me and he goes, this is not good. And so we sit down, he shows me the jury verdict form. It's, $12+ million. And I said, I knew it. I knew it was going to be good. So that's kind of the backstory on what transpired.
Well, I tell all my clients at the beginning of every case, I say, there's going to be times in this case over the next couple of years where I make decisions, and there'll be the decisions that I make. And, I'll talk to you about them. I'll tell you what I'm going to do. But I'm going to decide, who to be deposed and what questions I ask them and those kind of things. But there's also questions and the issues you're going to decide. And one of the things you're going to decide, it's not my case. I'll give you advice about resolution of this case, but the ultimate decision is yours.
Right. That's right. And look, here's the reality is, if we'd gone forward with the verdict, they would have appealed that to our Supreme Court. It would have been a longer period of time. I don't know what our Supreme Court would have done, right? I mean, they may, there's no telling what they would have done. She had a lot of money guaranteed to her, and I get it. And I was, at the end of the day, I was fine with it. But it's still tough. I'm just going to be honest with you. It was tough.
I know. So one of the questions we got from our guest were you able to record anything? Were you able to record any of the jurors' reactions? I know you said you couldn't see them at times. Were you able to record any of the witnesses? Anything was that recorded, or was it more like a standard trial?
Standard trial. The closed circuit television was simply for the jurors to have a close-up view of the witness because they were so far away. The judge had told us that in a criminal trial, because there is a right for the public to be present, they use closed circuit television in another courtroom for spectators to be able to see the trial. But nothing was recorded in either trial. It was just so people could observe. In our case, you could see the witness, see his or her expressions from the jury stand, and for a criminal trial, for the public to be able to view the trial and procedures.
Right, and we were just getting daily transcript.
Yeah.
At the end of the day.
So you've talked a lot about the precautions that were taken and the measures that were undertaken to protect people and to show witnesses. Did that change the length of the trial? We've got a guest who's got a trial coming up. Looks like maybe in the Eastern District of Louisiana in August, and the court there seems to be concerned about how these precautions could impact the length of trial. Did it take longer than normal?
I don't think so. I think, as in every trial, sometimes when you switch between one party taking a witness and the other party, there's a short break to allow the technology staff to switch everything over. Because obviously when we had a witness, our technology person is in control, so they can pull up our exhibits. And then when the defendant goes, they want their person in control. But after that one short delay, for any redirect, then you can use the same person because all the evidence is in. So we don't have to switch back and say, pull up exhibit 5. I want to talk about that some more, this particular witness. I do not believe it substantially lengthened the trial.
I thought voir dire took a little bit longer just to get everybody situated, and it was new and everybody's trying to figure everything out. But I'll say this, and I think it'll be true in your case too, there in Louisiana. Early on, there may be a little bit more of a drag, but I think once you get in the routine, I think you're going to be fine. I think that as you get in the routine and everybody gets comfortable with the environment, that the trial should proceed, assuming you have a judge that'll move things. Then I think it's going to be fine as long as the routine starts happening. I mean, we all know in non-COVID, if you have a judge that says we're going to take a 10-minute break and it's a 30-minute break, or says we're going to break for lunch for an hour and ends up being 2 hours. I mean, it's just those things drive me crazy. But this judge kept moving things along. I thought once we got in the routine, everybody was comfortable with the environment, that the case proceeded as any other case.
I agree.
Well, guys, I appreciate you coming in and joining us today and sharing your experience with us. It was a fascinating trial. I'm just so happy for the client. At the end of the day, that's what we do. We are here for them. I love the fact that that's what we do as lawyers. We're professionals. I always tell people that's what sets us apart from business people is that we are here to help people, number one. And that's what y'all did. You helped somebody. You helped a family who had lost so much. Thank you all for joining us. I hope you enjoyed it. I also hope you learned something. We'll be doing another webinar next month. So be looking for our emails on that and on social media where we will let you know the next topic. I'm excited about that one. And thank you again for joining us. It's been fun this morning.
Thank you so much.
Yeah.
Enjoy being here.
It's been great.